Welcome back. I'm Uday Pratap Singh. You're joining us on NewsX. Our big focus this hour, the Bombay High Court has acquitted all 12 accused in the 2006 train blast case, declaring them as innocent. The special bench of Justice Anil Kilor and Sham Chandok has overturned the lower court's order, saying that the prosecution utterly failed to prove case against them. 5 months ago, the High Court had reserved the matter for judgment. The bench said it refused to confirm the death penalty imposed on 5 of the convicts and also the life imprisonment on the remaining 7 and acquitted them. The court has said the accused shall be released from jail forthwith if not wanted in any other case. Let's give you a quick recap first of the case. The Mumbai bombings, remember, occurred on the 11th of July 2006 at approximately 6:25 p.m. IST. During rush hour, the attacks targeted first-class compartments of trains on the western line of the Mumbai suburban railway. 7 bombs exploded within a span of 11 minutes. 189 commuters lost their lives. 824 passengers were injured. Explosions occurred on trains near or at Mahim, Bandra, Khar, Borivali, Jogeshwari, Mira Road, Matunga stations as well. 8 pressure cookers had been purchased from 2 shops in Santa Cruz, each filled with 2 kilograms of RDX and 3.5 kilograms of ammonium nitrate and then placed inside the train. After 3 years in 2009, the arrested Sadiq Sheikh confessed to his alleged role in the bombings during a broadcast. A charge sheet was filed in November 2006. The trial court had in 2015 sentenced 5 to death and 7 to life imprisonment. Ansari, one of the convicts on death row, died in 2021 due to COVID-19. In July 2024, the High Court constituted a special bench led by Justice Kilor. The Bombay High Court has now acquitted all 12 accused, stating that prosecution failed to prove the case against them. What exactly was the legal timeline post the charge sheet that was filed in 2009? And who are these 12 accused that have now been acquitted? Let's quickly take you through those details before we open it up to our special guests. So let's begin by taking you through the legal timeline of this Mumbai train blast case. Remember, that occurred in 2006. On the 30th of November 2006, the Maharashtra ATS filed a 14,000-page charge sheet in a special Makoka court against 30 individuals. This, of course, was something that was done by the ATS in the state of Maharashtra itself, where these blasts had taken place. The charge sheet alleged a conspiracy by the Students' Islamic Movement of India, that was SIMI, with active support from the Lashkar-e-Taiba as well, the LET. In 2007 then, a special Makoka court formally framed charges against the 13 individuals who were arrested, all the accused, for alleged roles in their role in this incident, in bomb making and in planting of the explosives. The accused pleaded not guilty and the trial commenced in 2007 under provisions of Makoka. Cut to 2008, the trial progressed quite slowly due to voluminous documentation and forensic evidence collection. The statements were taken from about 200 witnesses in this particular case. The prosecution presented evidence of bomb assembly at Muhammad Ali Sheikh's Govandi residence. So this is, of course, something that had taken place in 2008 at that point. The prosecution also presented evidence of the bomb assembly at Muhammad Ali Sheikh's Govandi residence. Let's quickly please go to the next slide. It's a repeat of what we already told our viewers earlier. Okay. Well, we will, of course, keep getting you these details. But I just want to quickly bring in Sanjay Hegde as well, Senior Advocate, Supreme Court of India. Sanjay Hegde, appreciate you being with us live on the broadcast. What do you make of what has transpired today, the acquittal of 12 of the accused? What do you attribute this to, Sanjay Hegde?
Well, that's a call for a court to take. It's based on the evidence, it's reading of the evidence, and what happens often in these cases is that the agencies cast a very wide dragnet, pull in all and sundry, then try to prove a kind of disconnected case. And people who are involved in one case often get pulled into other cases as well. So when the defense starts collating everything that is alleged against the people and then starts pointing out the discrepancies, that is when the principle of beyond all reasonable doubt then comes in. Intelligence, the the investigating agencies are often pressurized both by the politicians as well as by media pressure to come up with fast results and close cases. They do not necessarily examine the evidence, or nor are they guided by lawyers who can tell them that, look, this appears to be a gap. Please find enough evidence to close those gaps. Do not shoot at all and sundry. Concentrate your case on only the accused who actually matter. This kind of wide spatter dynamics, which we have seen not only in this case, but we've seen in a host of other cases. Now, if you remember the people in Bhima Koregaon, people who were nowhere on the site have all been pulled in. There have been other cases like that. I've been dealing with a few. Once a person is pulled in one case, then they investigating agencies, primarily to prevent the person from coming out on bail, they add them to some other cases also, and then weaken all the cases together. It is time that there is a review of procedures followed by the investigating agencies. It is time that the cases and charge sheets that they file are pre-audited, and somebody takes responsibility for prosecuting them and to a successful conclusion, or at least to get into plea bargains and things like that with people who are not directly involved, who are peripherally involved in any case, so that at a later stage, an appeals court, which many years after the event reads the papers with a dispassionate mind and says, look, these are such gaping holes. I do not find a case which has been proved beyond reasonable doubt. That is what I assume has happened. One last thing before I stop.
Yes.
In this very case, there was Shahid Azmi, who was a lawyer there. And Shahid Azmi had made almost a similar kind of exercise earlier. And at the trial stage itself, had been able to elicit quite a few admissions. Unfortunately, the circumstances of his death are such that we do not really know.
Absolutely.
What fully
Absolutely.
happened.
Now, Sanjay, a quick follow-up question. What happens next? Do you believe this is a fit case which will be appealed in the Supreme Court? What is likely to happen next in this matter? And also, do you believe that all the accused could be actually released from jail? The court has said if they aren't wanted in any other cases, then they should be.
Of course, they should be released on jail if they're not wanted in any other cases. But as I said, that the investigating agencies might have very well pulled them into a few cases. That's what will happen, at least with the principal accused. Today, they are entitled to be released, and after 17 years, let us even assume the worst against them. Many of them would have been entitled to be released as having served a life sentence, or would have been entitled to remission thereafter. I think that this is a case which there will be an appeal. You can't expect the prosecuting agencies to sit tight and not file an appeal. But what an appellate court will do at a future stage, often when the record is big, the Supreme Court tends to say, okay, we'll look at it in our good time. And there have been cases where there have been acquittals by the High Court. For instance, there's been the Lajpat Nagar case where there was an acquittal by the High Court, but then it was overturned by a 3-judge bench of the Supreme Court. So if for today, the accused, those of whom are not facing any other cases, should be let out, and hopefully they can be rehabilitated in society and can go home with a clean name.
Okay, let me in fact also take that across to Sanjay Sahai now. Sanjay Sahai, come in here on this decision today by the Bombay High Court. What do you make of this acquittal? What do you attribute this to?
Yeah, I think Mr. Sanjay Agre has given graphic details as to how the trial would have been conducted, primarily on the evidence which was used in the Makoka court. So that is the basic evidence, and that is the evidence which will remain even when we go for appeal to the Supreme Court of India. What is really intriguing for me is that while the investigation was on, there were a large number of legal counsels who have had the investigation, and to my best of my understanding, good prosecutors were also there throughout the whole exercise. It has been a voluminous thing. There might be some discrepancies. I'm nobody to deny or support that nothing was there. But based on that particular evidence, the Makoka court gave a judgment out of 13, 12. 12 were sentenced, 5 for death sentence, and another 7 for life imprisonment. And most of the times, I'm intrigued with the fact based on the same evidence and the same jurisprudence, same procedure, same evidence evaluation. One court gives a totally different judgment compared to the other court. Now, here we have reached the High Court with all what has been talked about this case. I think there was certainly things which were in favor of the prosecution till the last judgment was pronounced. After that, I think 9 years have passed, and this judgment has come in. The evaluation, to best of my understanding, would have been on all cardinal principles of law. But I see that there is an opening when they go to Supreme Court of India, and as Mr. Sanjay Agade was saying, that in such voluminous sort of evidence and all that, Supreme Court also takes a line wherein they take their own time and then the case is decided. What is important is that as it reaches the Supreme Court, let it be decided in time. See, what is most important in the case of this nature, where 189 people got killed and 824 got injured, and there's a huge amount of conspiracy, and it is basically a terrorist act. If we are taking 19 years to decide and reach the High Court level, I think the pace of justice is literally injustice both for the prosecuting agency, it is for the accused, and it is for the country at large. And people will start believing that actually justice, the ends of justice will never be met. So I'm hopeful that this case will sail through in the Supreme Court. That is broadly what I can say at this particular point in time.
Okay, let me in fact also draw in NK Sood. NK Sood, where do you believe the lapse has happened which has led to this acquittal of all the accused by the Bombay High Court?
So basically, I can't say anything what the legal experts say, but the main thing is that the case has been utterly delayed, That's the most disturbing effect, And second thing I would like to tell you from my experience, from intelligence point of view, that there are a lot of pressures on the intelligence agencies and investigating agencies, especially during the Congress time. You take the case of 26/11. What happened in that? You take the case of 1993 blast. At that time, RAW was stopped from acting in the case, RAW's units, they were posted in the Gulf, they were not allowed to work, and RAW's units, the officers, they were shifted, so that RAW doesn't complete any investigation in this case, You take the case of Samjhauta Express, same thing happened. Pakistanis was involved, but they wanted to frame some other people. I mean to say, the government at that time, they wanted to protect Islamist terrorists. Same thing happened in the Malegaon blast case, So, I can tell you something, when Atal Bihari Vajpayee's government was there, at that time, even the intelligence agencies were specially told not to give any information against this Congress party, There were a lot of evidence, there were a lot of issues but they were suppressed, So, I think there was a planned manner, and I think these things are coming out more clearly now, that there was a planned effort to protect the Islamists, That is still going on. You take the case of Congress, Congress is doing that. That's their policy, It is not their policy from now, but from the years, you look back, I have a lot of instances, but I think mentioning those things will not be appropriate at the channel, But there was sufficient evidence, in the Bombay, in the 26/11 case, But nothing was done, They were not allowed to work, And even I told you that during Atal Bihari Vajpayee's time, our agencies were not supporting Atal Bihari Vajpayee. If you take the case of 1990 Kargil war, the information was not shared with him, with the PM. 2001, the parliament attack was there. Every information was available. that the terrorists are coming, but that information was not shared with the government. I think at that time even the deep state was working against India, against Atal Bihari Vajpayee. So I think that is all I would like to say.
Ashwini Dubey, this is of course a legal trial that was being watched by many. It has stretched on for many years, almost been about 2 decades. It began in 2006. What do you make of this acquittal today? What do you attribute this to, Ashwini Dubey, as a keen observer of law and of course an AOR yourself in the Supreme Court? And also what happens next now, Ashwini, in this case?
The first, prosecution has a right to appeal and challenge the order passed by the High Court. That's the basic remedy available under the criminal jurisprudence to any prosecuting agency and to individual as well. Now, to what would happen, it completely depends on the Honorable Supreme Court whether the High Court judgment would sustain or whether the detailed in-length trial with evidences conducted before the trial court, Makoka court, which has found that there was a conspiracy against the country and those who have been convicted were involved in the killing of 189 innocent citizens who were defenseless, and also those who were injured. Now, see, the trial court finding only for limited purpose cannot be ignored. There is a one court which is still there, because you have to see the conspiracy was hatched in the most calculated manner, almost in such a way that within a span of just 5 minutes, Uday, 7 powerful bomb blasts caused the disaster and 189 people died. Number 2, the time and target chosen is so significant that those they have planned, there was not only the internal insurgency but external people also involved. The terror wave which was created not only to disturb the country's environment, but also the life of the entire Mumbai city was totally disrupted. So these are the evidences. And evidence, you see, 1,839 pages judgment. The trial court have found that those people have committed this offense. Trial court has said the defenseless and innocent people have died who were traveling from church to Virar. Just saying, protecting them, that they are being targeted is not enough. We live in a country where rule of law prevails. The evidences are most significant manner. What transpired to the Honorable High Court, that's a matter which will rest before the Supreme Court. But as of now, what we have to see, who killed those 189 people, that is the most important question. Number 2, it is not an offense against an individual that yes, 17 years you have spent in the jail there for 17 years period is quite enough, and in 14 years you get the benefit of the remission. It is a case where 189 people died, and that was the complete terror attack. And I partially agree with Mr. N.K. Sood. Yes, very rightly, there are some pressure. I know many officers who even at that point of time, who in 2011, the offense was investigating, there was a pressure to file a charge sheet which was not related with the matter itself in order to save them. So it's the court have its own wisdom. I don't want to comment on the Honorable High Court's judgment, but yes, Uday, it is not the trial court judgment, Makoka court judgment cannot be overlooked in such a fashion that yes, since there is no evidence, the bombs used in the crime, bombs was used in the crime or not, that will be, even the detailed analysis will be heard. Number 2, the people who have been sent, who have died, who have killed them, this question will also arise. And if not them, then who? That question is there. Let's see what Honorable Supreme Court decide. But here the question is that those still people who have died, who have injured, is still waiting for the justice. Let's see what happens to all.
This was a horrific terror attack, Sanjay Hegde, and that is why the families of the victims would also be very disappointed with this judgment today. Who would you blame for the way this trial has really shaped up?
It is a horrific attack. I have been a Bombayite and I have traveled on those trains. Yes, but you should catch the right people who have done it, and you should present a foolproof case, because otherwise what happens is that the investigating agencies are under pressure, and so then they just rope in anybody. Tomorrow Mr. Dubey or Rai can be accused of having created those attacks, and then are courts merely supposed to rubber stamp anything that the agencies say? The court's job is to say, yes, give me proof beyond reasonable doubt. And once you present your proof, it has to be audited. Agencies and the prosecutors must act firmly and pre-audit before it goes into court. Right now, agencies are mollycoddled by using harsh laws, saying that confessions are enough and that everything and anything will go under Makoka. Makoka, Tawada, Pota, those kind of laws are used across the board under terrorism, which only weakens the professionalism of the agencies. And then it's very easy to say that, look, we did our job, we caught some people.
I'm going to have to leave it at that. We've run out of time. My thanks to our guests for joining us on this discussion. I'm slipping into a very short break. Don't go anywhere.